Okay, hello again. We're back. Um, this is going to be a lecture that has two parts. The first part of the lecture is going to be about Shepardizing cases, and the second part of the lecture is going to be about legal citation. So hold on to your hats, ladies and gentlemen. It's going to be a wild ride. All right. So I'm going to try to stop saying It's very distracting to you and to me, but I probably will do it anyway. We are at the homepage of Lexis here. You should go to the homepage of Lexis. What I'm going to do here is go to my history on the help button. I'm going to click on the help button. I'm sorry, the more button. Sorry, the more button. I'm going to open up the folders. I'm going to go to my Mark Sargent folder. I think I asked you to create one for him. You should be following along with me. I'm going to open the Mark Sargent folder. It actually appears at the top here. And we will see that we have some cases here that I saved. Let's go to Commonwealth versus Purdy. That's a case that helped my legal argument. I represented the Commonwealth, and the issue in my appeal that the defendant raised was whether or not a letter that the defendant wrote to his probation officer while he was being held awaiting his probation violation hearing, whether it was properly authenticated before the government introduced it into evidence, meaning did the government prove that the defendant actually was the author of the letter. The relevance of the letter is that this defendant decided to make some admissions about the case in the letter, and those admissions were used against him at a hearing, at the probation violation hearing. The letter was introduced into the evidence. He was sent to jail and he appealed, and that was one of his issues. So let's open up Purdy. Shepardizing. Okay, so here's the right-hand box that you get when you're going to shepardize a case. You've probably seen this before. Let's go through it. At the top here, this tells us first that there was no subsequent appellate history. Okay, what does that mean? It means that Purdy was not appealed to a higher court. It ended there. There was no appeal of Purdy, and it wasn't. So we know that it was not reversed or otherwise made bad law. Okay, we know that. We go down to here, and it says that there's 98 citing decisions. Okay, out of those 98, there's a caution sign for 3 of them. What does caution mean? It means we should probably read those cases, because caution sometimes means that the analysis of another case may call into question the validity of this particular case, of this Purdy case. Okay. Most of the time, caution does not hurt us. Most of the time, caution is our cases that are perhaps deciding the other way from Purdy, but they're saying, we're deciding the opposite from Purdy, but we have different facts than Purdy. So this is not Purdy, the court's saying, but so we're going to go with a defendant on this one, because Purdy was a Commonwealth case, a Commonwealth decision. It favored me, my side. These were probably 3 cases they are 3 cases I know that distinguish themselves. All right. We have 24 positive cases. That's good for you, because if you are putting together a legal argument, those are 24 cases that are on your side. So this is a good tool for research. You can click on the 24 and it will bring up those 24 cases, and you can read the relevant language. And you can use those cases to further support your position, which I did. I looked at those, and I think some of those were helpful to me. All right. Tells us out of those citing decisions, out of the 98 decisions, 2 were neutral. They really didn't go one way or the other. Cited by 73. I think that's the same thing. I'm not sure what that means. All right. So when we hit Shepardize this we could hit Shepardize this document. It will bring them all up. Or if we're looking for particular cases to support our position, we could go to caution, or we could go to positive. But anyway, we'll hit Shepardize this document. So there are the 98 decisions that occur, and you could see the followed by has the green next to it. Cited by means basically they're telling you it doesn't mean much at all. It was just cited, it was just referenced. Although you should look at it because they sometimes are not really accurate. But you're looking for generally if you're doing research, you're looking to see what cases follow it. Now, if you want to find out if this is good law, you need to go look at the caution cases, because the caution, you're going to need to make sure that, like I said, that the language in the caution cases doesn't call into question the validity of Purdy. All right. All right. So over here you have your further way to narrow it. Again, you can click on this. This is harmonized by, explained by. You've got different courts here. This tells us that a California court, there's one decision in a California court that cited this case. If we were interested in going out of state, we could click on that and find the California decision. Very unlikely you would need that. We can break it down by reported and unreported. We're generally interested in reported. Again, these are tells us there are 3 cases that analyzed it, 3 cases discussed it, 15 cases mentioned it. I'm not sure what the difference between analyzed and discussed is, but but these are ways to narrow down these 94 cases or whatever. And we can narrow it down by age, which is good because sometimes your boss may want you to get a recent case. So we can type it in here and get ourselves some recent case law. Okay. Let's go back to the Purdy decision. So I'm going to now talk to you about how to save time in your research, how to avoid wasting time by Shepardizing this whole document and having to sift through a lot of cases that may not be relevant to what you're looking for. In this particular case, I was doing research on the issue of authentication. The issue of what do you have to do to prove that someone is the author of the letter? Do you need a handwriting analysis to say that? Can it be just a signature of the person? So on and so forth. How do you prove that a letter came from somebody? Because I was the government. I wanted to prove that this letter was written by this defendant who made these damaging statements about his case. All right. So I go through, I get Purdy, and I don't read Purdy. I don't sit there and read the entire case. A lot of the case I couldn't care less about. Okay. I care about the first 3 headnotes here. The first 3 headnotes deal with what I'm talking about. I can just read them. Here it is. The role of the trial judge in jury cases is to determine whether the evidence, that there is sufficient evidence sufficient, if believed, to convince a jury by a preponderance of the evidence that the item in question is what the proponent claims it to be. If so, the evidence should be admitted. So this deals with authentication. This also says authentication right here. I'm interested in this. Go down to here. Again, computer and internet law, but if I read this head note, again, it deals with authentication. It talks about electronic communications present their own opportunities for false claims of authorship, so on and so forth. So I like those 3 head notes. I can click on each head note 1 and go right to the case and find where it talks about it. But what I'm trying to get to is when you are going to Shepardize this case, you are not interested in getting all the cases about that cite this. You don't care about Shepardizing, finding cases that are talking about sex crimes or pandering or pimping or the elements of prostitution. I couldn't have cared less than that. I don't care about the out of court statement, the rule of hearsay. I only care about authentication. So the point is we can just Shepardize by these narrow head notes here. I can see that there are 33 cases here. I can Shepardize by circumstantial evidence. I click on those, and that gives me those particular cases. Now, in this example I'm giving you, we didn't save much time because there are still 33 cases that dealt with authentication. But you will come across long decisions that have lots and lots of issues in them that you are not interested in and you don't care about. And you will save time if you can just Shepardize the head note that deals with the issue that you are looking into. Okay? Okay, I should tell you here that what I've been talking about with respect to Shepardizing, I've been talking about how to use Shepardizing as a research tool to find cases that support your position when you are writing a legal argument in a legal document. That's what I've been talking about. That's what I do on a daily basis. The other purpose of Shepardizing is just to find out whether something is still valid law, and that's probably what you'll be doing mostly. But in my course, I'm going to be teaching you some legal writing, and this is a tool. The Shepardizing is a tool to come up with cases that you can use. All right. Now, going back to the writing part of it, if you were asked to find by your boss some cases that support his position, and you were looking into cases and you came across Purdy, if Purdy had been reversed, it was no longer good law. Over here, you would see a big red stop sign that would tell you that Purdy was reversed, and that means that Purdy is no longer good law. But you have to be careful. Let me tell you this. That does not mean you cannot use Purdy to support your position, as long as the point of law on which Purdy was reversed is not your issue. So in this particular case, we're interested in the narrow issue of authentication. And it's, as long as Purdy was not reversed on the authentication analysis, we can still use it because it still supports our position and it's still good law with respect to that particular issue. That's why the head notes are important. That's why it's important to read the case and not just skip over a case if it has the stop sign and say, oh, that was reversed, I'll just go to another one because that's not good law anymore. No, actually, most of the time it has been reversed on some issue that's not your issue. All right. So, for example, in the Purdy case, if we read it, let's say Purdy was reversed and we got the stop sign. Maybe Purdy was reversed because the court incorrectly instructed the jury on the elements of prostitution, and there was some screw up on prostitution, and it's that specific issue of the case that got it reversed. That means that everything, all the other analysis is still good law, and we can still cite Purdy on the issue of authentication. And when we do that, all we need to do is at the end of the citation, put in parentheses, reversed on other grounds. That tells the reader that yes, it was reversed, but not because of the authentication issue. It was some completely separate issue. Okay, that's something you should know, and it's important to know for your day-to-day use. All right. Okay, I took a brief pause and I just changed the screen. It's probably abrupt for you, but we are now moving into part 2 of my lecture, which deals with legal citations. Like I said, it's a wild ride. So this is a handout that I put up on Blackboard that you can use when you do your exercises that I gave you. It talks about reading legal citations. It's from the Boston College Law Library, and it tells us the basics of citation reading and writing. You should know most of what I'm going to tell you right now. What is a citation? So this is a citation to a case. You know this, you should know this. The first part of the citation is the name of the case. If it's a civil case, it's so-and-so versus so-and-so. In Massachusetts, if it's a criminal case, it's Commonwealth versus so-and-so. In the United States, if it's a criminal case, it's the United Federal Court, United States versus so-and-so. Okay. So a correct legal citation form, Brown versus Board of Education, should always be italicized if you are writing it out in a brief or a legal document. Either italicized or underlined, but I'm going to tell you for purposes of my class, you should always italicize the case name. Underlining is an old format that's been used it goes back to the typewriter age, and people aren't using it anymore. All right, so italicize the case name, always follow the case name by a comma to separate it from the next part of the citation. We know that 347 U.S. tells us that this case appears in volume 347 of the U.S. Reporter. Okay, that's a volume. That's like a whole book. Okay, and then it tells us that the beginning of the case, it starts on page 483. That's where we find it, and that the case was decided in 1954. Okay, that is a general legal citation. Okay, we move down here, and here, Brown versus Board of Education, they've got it all, charted out like I just talked to you about. The important thing to know about this second cite is after 483, which is where the case begins at. We have the notation 490. 490 means that the person who wrote this citation would like us to turn to page 490 of Brown versus Board of Education, not to the, that's called a pinpoint citation. 90% of the time, you will be using pinpoint citations. When you're writing them out, you want to point to the reader to the page on the case that stands for the legal authority that you are relying on to support your argument. You don't want to cite the case and have some judge reading a 20-page case to find the quote that that's on the case that supports your position. Judges don't like that, and they won't like the writer for doing that. All right, so that's basic citation format. Statutes are set out here. The name of the statute. They've got it says public law, chapter number, and they've got it all diagrammed out here as well. Civil rights codes and so forth. I don't know what kind of practice you're going to be doing. You may be using some of these regulations. There are hundreds of publications each throughout the country. Obviously, each state has its own reporters and so forth. So there are hundreds of abbreviations. You can get down here. It just shows you some common legal abbreviations. It gives you most of the Massachusetts abbreviations for Massachusetts courts and statutes and so forth. All right, this is something you would need to look up in a volume. I am publishing something up there that's from the Supreme Judicial Court. It's the Court Reporter's Office, and it's their style manual for citing Massachusetts law. And you can use that as a guide in this course, and you can use it to do your exercises that I give you. You can refer to that as a manual of style as to how to cite different cite different things. All right. All right. Now I want to talk to you about short form citations. This is if you are writing a legal document and you cite a case, the full citation of the case. Once you cite the case with a full citation, you should never use the full citation again. You should always use a shortened or abbreviated form of the citation in order to save space, and again, in order to not unnecessarily annoy the reader. So we're going to switch our screen here. This is another handout that's up on Blackboard that you will see. It's short form citations. The most common form of short form citations is id. That's short for idem, which is IDEM. It's Latin, and it means the same or identical. I think of it as identical. It's a good way to remember it. So you can see it's id, it's underlined, but you should always italicize, never underline. That's going to be italicized, and it's going to be followed by a period because it is an abbreviation of that Latin form. What is id used for? So this tells you here in 1, 2, 3, id is just a short form that we use when we are writing a legal document and we write out the full citation of a case. And then in the very next sentence, we want to cite that very same case again. We don't write the case name out. We write id, ID, meaning the identical. We're referring to the identical case. All right, so you have here, he has Tennessee versus Garner here. That comes after his quotation. That quote comes from Tennessee versus Garner. We know it appears in the U.S. reports. It starts on page 1, and it's a pinpoint cite. The quote that he has appears on page 7 of Garner. Okay. In his next sentence here, he says, by contrast, Minimal police interference will not always constitute a seizure for Fourth Amendment purposes. And then he's got id. All right. So what does id tell us? It tells us that this sentence here, the authority for this sentence is Garner. It's in the exact same case, Garner at the same page, and it also appears on page 7. It's identical right down to the page number. Okay. What if this next sentence had a quote that was quoting something that appeared on page 8, not on page 7? Okay, so in other words, same case, everything's the same, but he puts another quote in there or another point of law, and he's referring to Garner referring to page 8. So anyway, he would put id at page 8. It would just be it at page 8. That would tell the reader that that next quote appears on page 8 of the Garner decision, not page 7. Okay, so those are the two ways to use id. But the important thing to know about id is it only is used when you are talking about a citation that occurred in the very prior sentence. Otherwise, it can be confusing. Obviously, if you use id 5 paragraphs down and to refer to Tennessee Garner versus Garner, and you've cited 3 or 4 different cases, the reader won't know what id is referring to. So we always use id in the sentence that appears in the next sentence, right? All right. Right here it says id. Okay. They also give you shortened citation forms here. Okay. Supra. What is supra? Supra is the same as id, but with supra, it's the example I gave you. We have Tennessee versus Garner, and we maybe write 3 more paragraphs or 3 more pages, and we cite a bunch of other different cases, and then we want to cite Tennessee versus Garner again. We would put the name of the first name of the case, or in this case, the second name, Garner, because would be Tennessee. So we'd put Garner, comma, supra at 33, at whatever the page number is. Okay. That tells the reader now that we are referring to the Garner case and that it's somewhere back in our memorandum of law or our document, but it's not in the preceding sentence. Id tells us it's in the preceding sentence. Supra tells us it's somewhere back in the memo. So supra always has to be followed by, usually we always follow it by a page number, where to find it. Okay. So the proper way to write it would be Garner, comma, supra, italicized, not underlined, at 33 or whatever the page is. Okay. And a new pin site at 33. That's what the new pin site is. Okay. So that's id and supra. It's pretty basic. It's a basic form of legal writing. You should know it also when you are reading cases, because obviously the cases that the judges are writing, the opinions, have id and supra in them. They do the exact same thing. Okay, I'm back, and I am going to finish out the lecture here. I can hear the applause and the gratitude coming out of you all. Commonwealth versus Mills. I just wanted to end this by showing you an example of a case that was reversed that you might be able to still use. I wanted to show you what that looks like. So I found Commonwealth versus Mills, and you can see that as the red stop sign there. You can't miss it. That means that this case it was reversed. We can see that this was an appeals court decision. If it was reversed in Massachusetts, the next court that would reverse it would be the Supreme Judicial Court of Massachusetts. Okay, so it was likely appealed to the SJC and was reversed. So let's go over to here, and we see that it says view the top citing reference. That's almost always the case. That will take us to the case that reversed it. Okay, so that will take us to the Supreme Judicial Court decision that reversed Mills. Okay, so we click on this. Oh, I'm sorry, that didn't do that, did it? Okay. I did that wrong. Let me see. Stop citing reference. Oh, okay, so yeah, it takes us to the top citing reference, and takes us to Mills again. So the name of the case that reversed it is also Commonwealth versus Mills, but it's a SJC case, not an appeals case. Okay, so we click on this Mills. All right, click on it here, and we click on it, and we know it's probably the case that reversed it because we know it is because it says Supreme Judicial Court. Okay, and if we read this decision, it says, okay, the Commonwealth filed an application for further appellate review of the judgment of the Appeals Court of Massachusetts, which reversed the judgment as to the indictment of larceny, reversed the adjudication of the defendant as to common and notorious thief, and vacated the sentence under Mass General laws. And it says, and remanded the case to the Superior Court for resentencing. The Supreme Court granted further appellate review. Because that's the procedural posture. It's kind of complicated, but what they're telling you here is that the defendant won the first round. He appealed and went to the appeals court. He got some of his convictions knocked out by the appeals court, and this court reversed. It was appealed to the Supreme Court of Massachusetts, and the SJC reversed the appeals court. Okay, so you can read on here, but the point I want to make to you is that if you read this case, you would see that this guy was charged with all kinds of different offenses. He was a retired police officer or something who was doing investigative work for the public defender's office. And they only, in this decision, only reversed some of them. They reversed the larceny, I think, and the embezzlement. And there were all kinds of charges. So the point is, if you were, researching a particular crime that was not reversed, you could use that. And you could use some of this stuff in your brief. You could use, for example, some of these general points of law. Let me see here. It says here, it is of paramount importance that justice be administered impartially based solely on relevant criteria for sentencing. You could use, you could use that. You could use a lot of stuff from that case that was reversed. You could use a lot of stuff from that as long as it was not reversed by the SJC. That's probably confusing, but I just wanted to show you one example of that. Okay. That's it. I'm going to leave the lecture now, and you'll be happy about that. Very good. All right.